Court officer, can you please call the case?
Good morning, Your Honor. This is case KAC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you. First of all, I will call the appearances. Mr. Prosecutor, could you tell us who's present for the Specialist Prosecutor's Office?
Good morning, Your Honors. Good morning, everybody in and outside of this courtroom. The prosecution is represented today by Mr. Alex Whiting, Acting Specialist Prosecutor, Prosecutors Silvia Dascoli and Filippo De Minicis, our case manager, Julie Mann, and I am Cezary Michalczuk, SPO Prosecutor.
Thank you. Victims' Counsel, you have the floor.
Thank you, and good morning, Your Honors. Good morning, everybody. The participating victims in this case are this morning represented by Jack Proven as Junior Legal Associate, Brechtje Vossenberg as Co-Counsel, and by myself, Annie Pusse as Counsel.
Thank you. Defense Counsel, you have the floor.
Good morning, Your Honor. Good morning, the people inside and outside this courtroom. The defense is represented by myself, Julius van Bonnet, lead counsel, my co-counsel, Mr. Betim Shala, investigator and interpreter, Mr. Fatmir Pillai, and investigator Avdi Mehmeti. And joining us in the courtroom is also present today, Mr. Salih Mustafa, the accused. Thank you very much.
Thank you, counsel. Now I turn to the registry.
Good morning, Your Honors, and good morning, colleagues. Jonas Nilsson, Head of Judicial Services Division, representing registry today, together with Head of Court Management, the Senior Court Officer. Thank you.
Thank you. Trial Panel 1 will render today the trial judgment in the case of the Specialist Prosecutor versus Salih Mustafa. The panel is composed of judges Roland Dekkers, Gilbert Biti, and Vladimir Mikula as reserve judge, and myself, Mappi Veldfolia, as presiding judge. This judgment is pronounced in public, in the name of the people of Kosovo, and in the presence of Mr. Mustafa. While I will read a summary of the central findings made by the panel, this summary is not part of the trial judgment, which is the only authoritative account of the panel's rulings and findings. The non-authoritative summary will be available on the website of the Specialist Chambers. These proceedings concern the alleged acts of Mr. Mustafa at a compound in Slash in Kosovo between approximately the 1st of April 1999 and around the end of April 1999. Today's judgment marks a milestone for the Specialist Chambers. It constitutes the first judgment for war crimes of this tribunal. It represents another step towards delivering justice and promoting accountability for serious violations of international humanitarian and criminal law allegedly committed in Kosovo between the 1st of January 1998 and the 31st of December 2000. Before turning to the panel's findings on the charges against Mr. Mustafa, the panel wishes to address a few important issues. Firstly, there seems to be a misconception that these charges were brought against the Kosovo Liberation Army as such, or against the people of Kosovo as a whole. Nothing could be further from the truth. It was the people of Kosovo, through their parliament, who chose to create and empower this institution. In addition, criminal responsibility before the Specialist Chambers is only personal. This principle is enshrined in the legal framework of the Specialist Chambers. It grants the Specialist Chambers jurisdiction over natural persons only. In the present case, the charges presented by the Specialist Prosecutor relate solely to the individual criminal responsibility of Mr. Mustafa and his involvement in war crimes of arbitrary detention, cruel treatment, torture, and murder as alleged in the charges of the Specialist Prosecutor. At no point in time the KLA was on trial. Mr. Mustafa and his alleged actions were on trial. Secondly, The victims alleged to have suffered harm because of the actions of Mr. Mustafa are citizens of Kosovo and of Albanian ethnicity. Their efforts to seek justice and truth lie at the heart of these proceedings. Finally, the panel has heard several first-hand accounts of witnesses, some of whom are also participating victims in the case. These witnesses testified on the traumatic events they experienced and the continuous psychological impact these events have had on their lives and on the lives of their families. The panel recognized that it takes a lot of courage to come forward to testify. The victims did so in a pervasive climate of fear and intimidation that persists in Kosovo to this day. Throughout the course of this trial, the panel has heard evidence from multiple witnesses indicating that those who cooperate or are believed to cooperate with the specialist chambers or with the specialist prosecutor are labeled in Kosovo as traitors or collaborators and are subject to threat and intimidation, either themselves or their children. The victims who have come forward as witnesses in this case now live in constant fear that something will happen to them or their families. They are still to this day unable to speak freely about the traumatic events they experienced and the harm they suffered. This climate of fear and intimidation directed against witnesses who provide evidence in investigations or prosecutions of crimes allegedly committed by former members of the KLA is one of the reasons why this court was created and is located here in The Hague and not in Kosovo. It's also the reason why the pretrial judge and the panel have put in place protective measures for witnesses and participating victims in order to conceal their identity from the public. The identity of the witnesses was disclosed to Mr. Mustafa and his lawyers to ensure his fair right to trial. As a result of the protective measures for the witnesses and participating victims, several trial hearings were conducted in private session, without the public being able to hear what was discussed in the courtroom. This guaranteed the effective protection of the identity of those who wanted to tell their story before this panel. For the same reason, the panel ordered the temporary segregation of Mr. Mustafa and some restrictions to his communications with the outside world. The panel, nonetheless, always has been attentive to the rights of Mr. Mustafa and has, at all times, balanced the interest of witnesses and victims on the one hand and Mr. Mustafa's rights on the other. I will now begin with a summary of the judgment. I will start with the accused and the charges. Mr. Salih Mustafa, the accused in this case, is a Kosovar national, born on the 1st of January 1972 in Pristina, Kosovo. According to the charges presented by the specialist prosecutor and confirmed by the pretrial judge, at all times relevant to the confirmed indictment, Mr. Mustafa was the commander of the BIA guerrilla unit, a unit of the Kosovo Liberation Army. According to the confirmed indictment, the BIA had its base in a compound in Zlaž, in the Golek region of Kosovo. This compound was allegedly used by the BIA as a safe house and as a detention and interrogation site. The specialist prosecutor asserts that the crimes charged were committed at this compound, and I will refer to it as the Zlaž detention compound, or the ZDC. The specialist prosecutor charged Mr. Mustafa with 4 counts of war crimes under Article 14, Paragraph 1, under C of the law. Arbitrary detention, count 1, cruel treatment, count 2, torture, count 3, and murder, count 4. The prosecution alleged that Mr. Mustafa is individually criminally responsible under various modes of liability pursuant to Article 16, Paragraph 1 under A and C of the law for the arbitrary detention, cruel treatment and torture of at least 6 persons at the ZTC between approximately 1 April 1999 and 19 April 1999. And for the murder of one person between approximately 19 April of that same year and around the end of April of 1999. Mr. Mustafa pleaded not guilty to all counts. I will give a short overview of the trial proceedings. The trial commenced the 15th September of 2021 with the opening statements of the Specialist Prosecutor's Office and the Victims' Counsel. The defense made its opening statements on the 22nd of March 2022. During the trial, the panel has heard 28 witnesses, 13 called by the Specialist Prosecutor and 15 by the defense. The panel has further considered written statements, documentary evidence, and expert reports. Moreover, 8 victims have participated in the proceedings, all of whom benefited from protective measures. Following the hearing of the closing statements, the presiding judge closed the case on 15 September 2022, and the panel enters its deliberation for the 90 days period provided in Rule 159, paragraph 1 of the rules. Let me turn to how the panel assessed the evidence presented in this case by the Specialist Prosecutor's Office and the defense. Prior to entering its factual and legal findings, the panel conducted a general assessment on the credibility and reliability of the Specialist Prosecutor and defense witnesses. The panel also took into consideration the impact that the prevailing climate of witness intimidation had on the evidence of these witnesses. As concerns the witnesses of the Specialist Prosecutor, the panel found that their testimonies were to a great extent clear, coherent, and consistent. Their descriptions were graphic, rich in detail, and narrated with emotion. Likewise, the testimonies of the witnesses corroborated each other and were further corroborated by other credible and reliable evidence before the panel. Overall, the panel found that the evidence provided by the witnesses called by the prosecutor was credible and relied on it, albeit to a different degree. Turning to the defense witnesses, the panel discerned several factors negatively affecting their credibility. These factors included strong and deep ties between the witnesses and Mr. Mustafa, rooted in their subordinate and superior relationship when they were in the BIA unit in 1999, and personal relationships, friends or related through family. Close interactions between witnesses and Mr. Mustafa before and after their interviews with the Specialist Prosecutor. Strong expression of distrust or bias on social media against the judicial process before the Specialist Chamber. And reluctance by several witnesses to provide information concerning the BIA and to associate themselves with any BIA-related activities. Moreover, the panel took into consideration the readiness of certain defense witnesses to align their evidence to that of other witnesses in a manner that was beneficial to Mr. Mustafa. The evidence presented by these witnesses was therefore considered with extreme caution. Further, some of the defense witnesses lacked a proper basis of knowledge to be reliably used. In other instances, their evidence was essentially irrelevant to the charges and therefore was not relied upon by the panel. Lastly, the panel found that many witnesses had problems remembering dates accurately or experienced memory lapses. Some of these witnesses were called by the defense to testify about a possible alibi. The panel considered the systematic difficulties in remembering dates as a factor potentially affecting the reliability of the witness evidence when assessing the alibi presented by the defense. I will now go into the role of Mr. Mustafa. Let me briefly summarize the panel's finding in relation to the role of Mr. Mustafa within the KLA at the time relevant to the confirmed indictments. The panel found that in May 1998, Mr. Mustafa was appointed as the commander of the then newly created BIA unit. The BIA unit formed part of the KLA. Mr. Mustafa held this position until approximately mid-June 1999, when the BIA was disbanded. Mr. Mustafa was known by the nickname Sali and was also referred to as Commander Sali. As stated by Mr. Mustafa himself and corroborated by ample evidence, he was the overall and only BIA commander throughout the BIA's existence, including in April 1999, and was also in charge of evidence gathering. Mr. Mustafa had the power to make appointments within the BIA unit, to issue orders to his subordinates and to discipline them. Before moving to the panel's finding in relation to the crimes charged, I will summarize the findings concerning the alibi. The defense submitted that Mr. Mustafa could not have committed the crimes charged. It averred that during the time relevant to the charges, Mr. Mustafa was in other locations than the / detention compound. The panel has carefully analyzed the totality of the evidence and found that such evidence did not establish a reasonable doubt with regard to Mr. Mustafa's presence at the crime scene. In particular, the panel found that the evidence of alibi was mostly vague or inconsistent, particularly when weighed against the consistent and ample evidence pointing at Mr. Mustafa's presence at the crime scene at relevant times. In addition, credible and corroborating evidence, including from Mr. Mustafa himself, showed that he was able to move across the territory surrounding Slash, and in fact did so repeatedly during the course of April 1999. I turn now to the panel's findings in relation to the crimes charged in the confirmed indictment. I will start with count 1 regarding arbitrary detention. Based on the evidence taken as a whole, the panel found that at least 6 persons were deprived of their liberty between approximately the 1st of April 1999 and on or around the 19th of April of that same year at the / detention compound. Victims were apprehended by BIA members or other KLA members in different locations around Slash. They were then handed over to BIA members at the / detention compound. The evidence clearly proves that the / detention compound was under the sole control of the BIA and his commander, Mr. Mustafa. The panel found that at no point during their detention, the victims were provided with any of the basic procedural safeguards that are mandatory under international humanitarian law for persons deprived of their liberty. Specifically, they were not informed of the reasons for which they were deprived of their liberty. They were not brought before a judge or other competent authority, and they were not provided with an opportunity to challenge the lawfulness of their detention. In addition, the evidence established that Mr. Mustafa was present at the / detention compound on various occasions during April 1999. These included the time when one of the victims was handed over to BIA members at the / detention compound at the beginning of April, and other instances in the course of the first 2 weeks of April 1999. The panel also found that Mr. Mustafa ordered his BIA subordinates to take detainees back to their place of detention after they were interrogated. Accordingly, the panel found that Mr. Mustafa intentionally deprived the victims of their liberty and knew that no basic guarantees were afforded to him for the entire duration of their detention. The panel therefore found that the specialist prosecutor has established beyond reasonable doubt the war crime of arbitrary detention under count 1. and that it was committed against at least 6 persons at the Slash detention compound between approximately the 1st of April 1999 and on or around 19 April 1999. I now turn to counts 2 and 3, which are cruel treatment and torture. The panel found that the detainees at the Slash detention compound were held in inhumane and degrading conditions of detention. They were kept in barns suitable for animals, in deplorable conditions, with livestock excrements lying around. They had to sleep on the ground, in water puddles or hay. In the barns, it was always dark. The detainees were not provided sufficient food. Witness testified that 2 or 3 days would pass without them having anything to eat at all. The detainees were also not provided sufficient water, and when they asked for water, BIA soldiers urinated upon them, saying, "Here is water for you." They were only given limited access to a toilet and were forced to relieve themselves inside the barn in a bucket in front of each other. The panel also found that the detainees were denied medical care and were prevented from talking to each other under threat of death. Furthermore, the evidence shows that Mr. Mustafa and his BIA subordinates at the Slash detention compound routinely assaulted the detainees, both physically and psychologically. The BIA members had a certain modus operandi. Inside the barns where the detainees were kept, the victims were kicked, punched, and slapped on a daily basis. In addition, BIA members took detainees out of the barns, one by one, and brought them, most of the time, to a room located above one of the barns, where they endured harsh interrogation and brutal beatings. The detainees were beaten, often by several BIA members at the same time. They were hit with baseball bats, iron and rubber batons. They were burned, electrocuted, stabbed, kicked, punched, and slapped. They were subjected to harsh interrogation and accused of being spies, Serb collaborators, traitors, thieves, or liars. They were ordered to express support for the KLA and made to shout, "Death to the traitors, death to the thieves, death to the thugs, and glory to the Kosovo Liberation Army," as one witness recalled. The mistreatment left the detainees severely injured, bruised, covered in blood, unable to stand or speak, and sometimes even unconscious. One detainee, the alleged murder victim, was so severely mistreated that he ended up in a near-to-death state. One witness testified in a manner that is revealing of the extreme suffering that he endured, that he wished he had been killed. Mr. Mustafa himself interrogated and mistreated 2 of the detainees personally on different occasions. He subjected one of them to a mock execution. He also beat him repeatedly all over his body. Mr. Mustafa further ordered his subordinates to beat one of the detainees until he lost consciousness and was present at other times when the detainees were mistreated by the BIA subordinates. The detainees were also psychologically abused by BIA members. From the barns where they were kept, they could see and hear their co-detainees being beaten and saw the injuries inflicted on them. As a result, they lived in constant fear that they could be next. One witness stated, "You could hear people screaming, howling like dogs, making sound like cats, screaming cats, because of the torture and the pain." Another explained that they could hear this almost every night and that they could not sleep. The testimony of one witness speaks for itself about their immense psychological strain. "You just stayed and waited who will come to get you and take you upstairs for beating. You were just waiting for death when it will come. Today, tomorrow, you were waiting to be killed." The physical and psychological abuse coupled with the inhumane and degrading conditions of detention, left the detainees with long life injuries, both psychological and physical. The panel thus found that Mr. Mustafa and his BIA subordinates intentionally inflicted severe physical and mental pain and suffering upon at least 6 persons detained at the detention compound for the purposes of obtaining information or a confession, punishing, intimidating, coercing, and or discriminating against them on political grounds. Taking the mistreatment suffered by the victims as a whole, the panel therefore found that the specialist prosecutor has established beyond reasonable doubt that the war crime of torture under count 3 was committed against at least 6 persons at the detention compound between approximately the 1st of April 1999 and on or around 19 April 1999. The panel considered that the charge of cruel treatment was fully consumed by the charge of torture, and thus decided not to consider it further, and this was for reasons of fairness to Mr. Mustafa. Let me move to count 4, the murder. The panel determined that on or around 19 April 1999, in light of the impending Serbian offensive in the area surrounding Slash, BIA members, under the authority of Mr. Mustafa as their commander, released a number of detainees from the detention compound. They also evacuated the premises of the compound. Nevertheless, and despite the exceptional circumstances created by the offensive, the panel found that 2 specific detainees were not released by Mr. Mustafa, BIA subordinate. These 2 detainees were not coincidentally, in the panel's evidentiary assessment, the 2 most mistreated. One of them was last seen by his co-detainees in a near-to-death state, unable to move. He was later found dead. The panel found that the identity of the body of the victim was positively established through a combination of testimonies, documents, and photographs as one of the 2 detainees who were not released from the detention compound. Considering that Mr. Mustafa was the overall and only commander of the BIA, with full control over the detention compound, the panel found that the only reasonable conclusion was that Mr. Mustafa took the decisions to release specific detainees and to keep the murder victim in detention while denying him medical care. These decisions taken by Mr. Mustafa in his capacity as BIA commander and in the context of the impending Serbian offensive effectively equaled the decision to kill the murder victim, as at that stage he was denied any chance of survival. The panel concluded that the murder victim died between on or around 19 April 1999 and around the end of April 1999. The causes of death were the severe mistreatment inflicted by the BIA members who detained him for almost 3 weeks, the denial of medical aid by those BIA members, and certain gunshot wounds identifiable on his body. The evidence irrefutably demonstrated that the first 2 causes of death, namely the extreme mistreatment inflicted upon the murder victim and the denial of medical aid, are exclusively attributable to acts and omissions of Mr. Mustafa and his BIA subordinates at the detention compound. With regards to the 3rd cause of death, namely the gunshot wounds, while the most probable conclusion was that BIA members fired the bullets at the murder victim before leaving the detention compound, this was not the only reasonable conclusion based on the totality of the evidence. There exists, in fact, a reasonable doubt as to whether the gunshot wounds identified on the body of the murder victim could be attributed to the BIA members or to the Serbian troops, for reasons explained in detail in the judgment. Nevertheless, the panel concluded that this reasonable doubt had no bearing on the attribution of the victim's death to Mr. Mustafa. This was the case because the extreme mistreatment inflicted upon the murder victim, jointly with the denial of medical aid, in the context of Mr. Mustafa's decisions as BIA commander to neither release nor evacuate the victim when the Serbian forces approached the area, constituted substantial causes to the victim's death, irrespective of whether the victim was hit by one or more Serbian bullets. In other words, the panel considered that firing directly at the murder victim or putting him in a position to be fired at by the advancing Serbian forces, by abandoning him without protection in a near-to-death state at the detention compound, led exactly to the same conclusion. The conclusion is that the death of the victim could be attributed to acts and omissions of Mr. Mustafa in his capacity as BIA commander. Accordingly, the panel found that Mr. Mustafa intended to kill the murder victim. The panel therefore found that the specialist prosecutor has established beyond reasonable doubt that the war crime of murder under count 4 was committed against one person at the detention compound between approximately 19 April 1999 and around the end of April 1999. I will now turn to the armed conflict. The panel further found that the crimes charged were committed in the context of a non-international armed conflict between the KLA and Serbian forces. Mr. Mustafa was aware of the circumstances establishing the non-international armed conflict. He was also aware of the status of the victims as not taking active part in the hostilities, given that they were deprived of their liberty at the detention compound under his control. Allow me to turn to the nature of Mr. Mustafa's participation in the commission of the crimes charged. The panel found that Mr. Mustafa directly and personally mistreated 2 detainees. In this respect, the panel considered it appropriate to reflect his conduct under direct commission as a mode of liability. The reason is that Mr. Mustafa intended to engage in that conduct, including with the required purpose of torture as a war crime. With regard to the remainder of the crimes, Mr. Mustafa, together with his BIA subordinates and other KLA members, shared the common purpose to detain and mistreat the detainees under BIA's custody at the detention compound, and to detain, mistreat, and ultimately kill the murder victim. The panel found that Mr. Mustafa significantly contributed to the implementation of the common purpose. In particular, Mr. Mustafa provided multiple significant contributions to the common purpose in his capacity as BIA commander at the ZDC. He personally tortured 2 detainees, thereby providing a model or incentive for his BIA subordinates to perform similar actions against the detainees at the ZDC. He ordered his BIA subordinates to torture some detainees and to return them to their barns. He denied medical care to the detainees despite their mistreatment and injuries. He did not release the detainees, thus allowing his BIA subordinates to mistreat them until an exceptional change of circumstances occurred, namely the Serbian offensive. And he never released nor evacuated the murder victim, who remained in detention while Mr. Mustafa and his BIA subordinates left the detention compound in light of the impending Serbian offensive. In light of the above, the panel finds that Mr. Mustafa is criminally responsible as direct perpetrator for the war crimes of torture under count 3, limited to those incidents against 2 specific detainees in which Mr. Mustafa personally participated. The panel further finds that Mr. Mustafa is criminally responsible through his significant contribution to a joint criminal enterprise for the war crimes of arbitrary detention, count 1, and torture, count 3, against at least 6 detainees, as well as for the war crime of murder, count 4, against 1 detainee. About the sentencing. Before pronouncing the verdict and the sentence, I will briefly summarize the purpose of sentencing and the factors considered by the panel to determine the appropriate sentence for the crimes of which Mr. Mustafa is criminally responsible. Prior to that, the panel wishes to inform that it will issue in due course a reparation order pursuant to Articles 22, paragraph 8 and Article 44, paragraph 6 of the law, and retains the necessary jurisdiction to that effect. The panel recalls retribution and deterrence as primary purpose of sentencing an individual convicted of a crime. Moreover, the panel wishes to underline the importance of bringing to justice the perpetrators of those serious crimes of concern to the international community as a whole in order to end impunity. Even decades after the events concerned and notwithstanding a prevalent and long-standing climate of witness intimidation in Kosovo. Another important purpose of sentencing is the acknowledgement of harm and suffering caused to the victims and society. The panel lastly notes that the crime in this case were directed exclusively against Kosovar Albanians. And the panel is of the view that the establishment of the truth resulting from this judgment may further the reconciliation among affected communities in Kosovo in order to contribute to the restoration and maintenance of the peace. The panel considered the gravity of the crimes and its consequences, Mr. Mustafa's personal contribution to the crimes, the individual circumstances of the convicted person, and mitigating and aggravating circumstances as factors relevant to determine the appropriate sentence. As to the gravity of the crimes, the panel considered that arbitrary detention is grave in nature because it exposed victims to other additional human rights violations. Torture represents an assault to human dignity, security, and mental and physical well-being. And murder is inherently one of the most serious crimes. In this case, at least 6 detainees were deprived of their liberty at the ZTC in inhumane and degrading conditions, without any basic guarantees, and were routinely, psychologically and physically assaulted. Moreover, one of the detainees died as a result of the severe mistreatment inflicted by the BIA members, who detained him for almost 3 weeks. The denial of medical aid by the BIA members and the gunshot wounds identifiable on the body, in respect of which the panel has established that there exists a reasonable doubt as to the attribution to the BIA members or the Serbian forces. In this respect, the panel does not take into consideration this last cause of death when determining the sentence. As to the consequences of the crimes, the panel considered that the victims in this case suffered long-lasting injuries, both physical and mental. They also experienced disruption in personal relationships and family life. Some further struggled to make a living. The panel also took into account not only the impact the murder had on the direct victim and those who witnessed his mistreatment, but also on the family members of the murdered victim left behind. The panel further considered 2 aggravated circumstances, namely that, as described earlier, the torture was committed with particular cruelty and that victims were particularly vulnerable or defenseless, given their status, isolation, and in some instances their young age. One of them was, for example, 18 years old. For these reasons, the panel assessed the gravity of the crimes considered as high. As to Mr. Mustafa's personal contribution to the crimes, the panel considered the superior position and central role of Mr. Mustafa in a system of illegal detentions and tortures at the ZTC. Together with his continued approval and endorsement of the same acts in the period between the 1st of April 1999 and the 19th of April 1999. The panel considered for the sentence also that he personally and intentionally tortured 2 of the detainees. Furthermore, the panel considered that Mr. Mustafa intended the lethal treatment inflicted upon the murdered victim and for such mistreatment to carry on for 19 days, with denying medical care, basic guarantees or releasing him, which he had the power to do so as BIA commander. And eventually Mr. Mustafa, in his capacity as BIA commander, decided not to release the murder victim, which effectively equaled a decision to kill him. Accordingly, the panel assessed the degree of Mr. Mustafa's personal contribution to the crimes and his extent as very high. Finally, the panel did not accord any significant weight to Mr. Mustafa's individual circumstances, considering the nature and the gravity of the proven crimes and his contribution to them. I will now pronounce the verdict. Mr. Salih Mustafa, please stand. In the name Mr. Mustafa, would you like to put on your headphones? Okay, very well. In the name of the people of Kosovo, for the reasons set out in the judgment and summarized earlier, and having considered all of the evidence and the arguments of the parties and victims, Counsel, the panel, pursuant to Article 43 and 44 of the law and Rules 158, 159, 163 and 165 of the rules, finds you, Mr. Mustafa, guilty of Count 3, torture as a war crime under Articles 14, Paragraph 1 under C, little I, and Article 16, Paragraph 1 under A of the law, direct commission. Count 1, arbitrary detention as a war crime under Articles 14, Paragraph 1 under C and Article 16, Paragraph 1A of the law, as part of a joint criminal enterprise in its basic form. Count 3, as a war crime under Articles 13, Paragraph 1C, little I, and 16, Paragraph 1A of the law, as part of a joint criminal enterprise in its basic form. Count 4, murder as a war crime, pursuant to Article 14, Paragraph 1 under C, little I of the law, as part of a joint criminal enterprise in its basic form. The panel finds you not guilty of the war crime of cruel treatment under Count 2. And I will now pronounce the sentence. Mr. Mustafa, given that you have been found guilty of more than one crime, the panel has determined an individual sentence for each crime of which conviction has been entered, pursuant to Rule 163, Paragraph 4 of the rules. I will thus first set out these individual sentences. Thereafter, I will pronounce a single sentence for the totality of your criminal conduct. The panel has determined a term of 10 years of imprisonment for the war crime of arbitrary detention, Count 1. A term of 22 years of imprisonment for the war crime of torture, Count 3. And a term of 25 years of imprisonment for the war crime of murder, Count 4. The panel sentenced you to a single sentence of 26 years of imprisonment with credit for the time served. Mr. Mustafa, you may be seated. The registry shall now distribute the trial judgment in its electronic form. Please proceed. A certified copy of the English version will be provided to Mr. Mustafa as soon as possible today. And the Albanian version shall be served on you once it is ready. The panel will issue a public redacted version in due course of this trial judgment. And the panel recalls that it will retain jurisdiction in this case as said for the purpose of issuing in due course a reparation order, specifying appropriate reparation to or in respect of victims in accordance with Article 22, paragraph 8 and 44, paragraph 6 of the law. And before adjourning, the panel will also give an oral order. The panel considers that the remaining restrictions to contact and communications of Mr. Mustafa are no longer necessary nor proportionate at this stage of the proceedings. Accordingly, the panel hereby decides to lift proprio motu any such measures effective Wednesday, 21 December 2022 at noon. The panel will issue a written decision next week in accordance with Rule 75, paragraph 2 of the rules. The court stands adjourned.
All rise.